We are going to move on to 3 presentations about the current state of trials and appeals. First of all, we're going to hear from Mr. Futoshi Yasuda, who's the Director of the General Trial and Appeal Department of the Japan Patent Office. Today I'm going to talk about the latest trends of trials in Japan. I have these 3 topics that I want to talk about. First of all, the online and IT digitalization progress, then revisions of systems, and then messages for users and international relations. This is our trial and proceedings flow. There are basically 3 sides here. So I'm going to give a brief explanation of this slide here, but I'm sure you understand that anybody can give an opposition in this proceedings. As you can see in these 3 beige-colored points, there are 3 stages: interviews and applications and oral arguments. So I'm going to introduce these 3 first. First of all, this is a slide about online oral arguments. So before, we expected everybody to come to the JPO to give arguments in person. However, from October 2021, we allowed people to do this online. As you can see on the slide, you can see that online participation is acceptable. So you can also, you don't have to participate online. You can, the parties can participate in person as well as online, as you can see here. The judges' bench, as you can see here, each of these seats on the bench is provided with monitors. These are this system started in October last year, so we've had these proceedings for about a year now. We have now had 99 cases, and of these, 70 were carried out online, around 70%. Moving on to the next slide. From 2019, we introduced a dedicated online TV conferencing system, but we decided to abandon this, and then from last year we moved to a system involving Microsoft Teams. So now you don't have to come all the way to the JPO, and you can take part in interviews remotely. And so if there's anything that you want to communicate to the JPO, you can do it online by this procedure. Now, the proceedings, we've also worked to digitalize application proceedings. The judging proceedings still require a large number of paper documents. And in some cases, we only accept paper applications. However, the Japanese Patent Office from March 2021, we have added a digital submission system at the JPO, and we can submit documents online as well as in paper formats. As you can see by the picture here, you can see what type of attachments that you can send to the JPO. As you can see these 3 here. These attachments include evidence and we will establish this system fully by 2023. So we have this system has been introduced on a trial basis at first. From the beginning of next month, we are going to allow the submission of evidence by DVD-R. As I've said, that this system will be introduced starting from next week. So it means that parties can submit one single DVD-R instead of multiple files and multiple documents. And this DVD-R will be treated as the original of the documents. So we used paper as the original documents, but with digitalization, we have created this submission form for electronic documents. And this form will be used as well in the case of the submission of the DVD-R. And we're very grateful that we've been able to continue this system that we have introduced into the past. Around 50% are using, 50% of cases are using this submission method. Let me move on to the system amendment and the relaxation of requirements. As this slide shows, we have revised the acceptance requirements for parties in many cases. So it's very difficult for people to obtain all of these qualifications. We have relaxed the requirements for certain proceedings. In the term of contracts, if required, contracts can be issued for amendment by this system. So finally, I want to move on to how we communicate with users and how we carry out international liaison. We have a practical study meeting for judges, and this has been carried out since 2006. This is an extremely useful study meeting, and we get feedback from actual working judges about the system. The details of this system are shown in detail on the homepage, and as it shows here, we use this system to judge the necessity for making various amendments and revisions. And we have some very interesting topics come up in this study meeting. This is an advertisement that you can see here. This is part of activities to make the judicial system more widely known. So we have a judgment system for patent invalidation and things like that. However, some people say it's quite difficult to understand this system. Recently, we've issued a guidebook, a leaflet about the system to make it easier to understand. We also have an English version available. And in this case, following these proceedings, we can come to conclusions very quickly in a minimum of 3 months. So I'd like to move on to a category about judgments. These are judgments about the necessary for standardization. So we are trying to achieve early decisions in disputes related to standardization patents. This slide talks about proceedings related to revoking patents of not used. And a large number of unused rights are revoked along this system. So we have created a leaflet that explains this system very simply. We also have created videos for people to watch. And there's various figures and datas about the revocation of rights that are not being used. Finally, I'd like to talk about international liaison. As explained here, we have various meetings with people related to the judgment system in different countries. You'll meet some of the people in these photographs today. You can see at the top left we had a conference with Europe in June of this year. And we talked about education systems and so on. Then in September we had consultations with China about various aspects. Then finally we have this International IP Symposium that we are holding today. This is the 6th such symposium. And we have had different topics. We've had topics involving Japan, China and Korea and ASEAN. This is an international symposium, and through this type of symposium we are talking about and introducing activities in different countries. Thank you for your attention. That's the end of my lecture.
Thank you very much. The next is Mr. Scott Borick, Chief Administrative Patent Judge, United States Patent and Trademark Office. Mr. Borick, please begin.
Konnichiwa. Thank you so much for inviting me to this symposium. I am Scott Bolick, the Chief Judge of the Patent Trial and Appeal Board at the United States Patent and Trademark Office. And I'm going to be talking about some of the new developments at the United States Patent and Trademark Office's Patent Trial and Appeal Board. First of all, before I start with my slide presentation, let me tell you a little bit about the board. We have about 240 judges and about 100 support staff organized into 4 divisions of judges, and we have 28 sections organized by technology. The judges perform both appeals from rejections of examiners and also post-grant trials. We'll talk more about those systems later in the session. But right now we have judges at our headquarters in Alexandria, Virginia. We have 4 regional offices across the United States, and quite a few of our judges are teleworking. In fact, right now, over 80% of the Patent Trial and Appeal Board is teleworking. So that's consistent with the rest of the U.S. Patent Office. We have about 80% of all of the examiners are teleworking at the moment. So one of the topics is our hearings have changed because of the pandemic. And so that's my first topic, is the PTAB hearings in the new normal. Back in March of 2020, literally over the course of the weekend, the USPTO decided, because of COVID, to close its buildings to the public and transition to a full-time teleworking posture. So we had in-person hearings on Friday, and come Monday morning, we transitioned to 100% virtual hearings. Since March of 2020, we've held over 2,300 virtual hearings. You can see that they're about split fairly evenly between appeal and trial hearings that we've held. We've also provided the ability for the public to remotely access the hearings, and they've taken advantage of that. In over 600 of the hearings, we've provided either an audio or a video channel for members of the public to watch our hearings. Most of these requests are approved. About the only time we don't approve a request is if there's confidential information that needs to be discussed. Normally, this is confidential business information having to do with secondary considerations of non-obviousness. But you can see most of our hearings are open to the public. Some of the benefits, and we've heard about this yesterday, so I won't spend too much time on this, but other tribunals have found it saves time and money for the clients. It lessens the environmental impact of having to travel either by airplane or by car to the hearing location. It is a little easier to share the demonstratives because everybody is remote. So unlike a hybrid hearing, which was our practice before going to entirely virtual hearings, was a hybrid format where the attorneys and at least one judge were in person and one or two judges appeared remotely. It was sometimes difficult for the remote judges to properly see the exhibits if they were being projected onto a screen in the hearing room. That problem disappears in all virtual environment. We have the ability for all of the judges to have virtual backdrops, so there's a consistency of appearance, and all of the judges are the same size box on your screen. In the hybrid format, you would see one live judge or two live judges and one or two judges on a remote monitor. And also it's easier for parties who want to watch the argument without having to come to our actual hearing room. So we found a number of advantages. We're going to continue virtual hearings for appeals and trials, and unless both parties want an in-person hearing, for the present, we will default to an all-virtual hearing. But if both parties, or if it's an appeal, if just the appellant want an in-person hearing, then we'll grant an in-person hearing. So most of the time, what you'll find is if you have an in-person hearing, it will be a hybrid format where one or two judges will be in person and the remaining judges will be remote and show up on a monitor in our hearing room. And again, that was our norm before COVID. So I've already covered this, but the parties can request the hearing. However, it is ultimately the selection of the Patent Trial and Appeal Board panel as to what kind of hearing is offered, whether it's in person or all virtual. For example, if a request is made for a hearing in our California office, but none of the judges are from our California office, we will not grant that. So it is ultimately the panel who decides. I think I've already covered this as well. One thing is that our hearing rooms do have limited capacity, so we will still potentially be able to grant public access remotely, but again, not if there's confidential information being discussed. Our hearings are either completely open or completely closed. We don't have a hearing where we close only part of the hearing. Now I'm going to talk a little bit about our interim process for director review, and just watching the time and the number of topics, I'm going to pick up the pace a little bit here. To set the stage for director review, there was a decision by the United States Supreme Court we call it Arthrex for short. And what the Arthrex decision did is it provided a mechanism for the director of the USPTO to review final decisions of the Patent Trial and Appeal Board before it wasn't clear that the director had the ability to single-handedly review these decisions. But the Supreme Court said the director can single-handedly review PTAB final decisions. And so we've implemented an interim procedure for this director review process. Of course, either the party has the option to request director review. They can still directly appeal to the U.S. Court of Appeals for the Federal Circuit, but if they request director review, we have an interim procedure, and our director has just concluded a set of requests for public comments on the director review procedure. I'll get to this later, but the intention is to proceed with a formal notice and comment rulemaking to solidify the procedures and make them permanent around director review. But one of the goals is really to help promote transparent decision-making and to ensure that we issue and maintain strong patents. The interim process, we allow parties to ask for director review of certain kinds of PTAB decisions, but not all of them. But the director has the ability on her own to initiate what we call sua sponte or on her own review. So a party doesn't have to ask if she sees a decision that she wants to take on director review. She can take it whether it is the kind that we allow the public to request or whether it is not. So all of the decisions of the board are available for her to choose to review. And she can address any issues, including issues of fact or law, and she doesn't give any deference to the panel who had decided the matter. In the materials, there are some websites that I refer you to if you'd like some more detailed information about the procedure and how it works. Just a quick review is, as I mentioned, the party can request review of final written decisions in an inter-parties review or a post-grant review, but only a party to the case can request this review. We do not allow third-party requests. And at the moment, we're not charging a fee. That's something that could be done in the future, but at present, there's no fee to request it. The party has to decide whether they want to request panel rehearing or director review. They cannot request both, at least in our interim procedures. That was one of the questions that we've asked, whether we should modify that practice. This slide here shows you the reasons why director review may typically be granted, and it's that middle bullet that gives you the main reasons why. And we do encourage the parties to give us a priority ranked list of the issues that are raised. Most of the time it's for more big picture policy reasons, but the director also can do error correction. If the panel has made a mistake in their analysis, the director can either correct that, but a lot of times it's because because there's a new issue of law or policy or the interpretation of our regulations or our governing statute that she wants to set forward for the office, or to resolve a split in the board. Sometimes board panels have differing interpretations. This is a procedure whereby the director can unify the approach for the Patent Trial and Appeal Board. So we've also requested, if there's an issue of first impression, and 10 years on, it's still amazing to me how many issues of first impression we still face. But to please indicate if this is an issue of first impression. Otherwise, please indicate the points of legal authority for the position that you're taking. I won't go into too much detail here, but you can read on our website that the director has set up an advisory committee made up of all of the major components of the U.S. Patent and Trademark Office that give her advice on whether a case should be taken or not on director review. Ultimately, it is her call as to whether to grant director review or not, and if review is granted, then that will be made known to the parties, and we'll post the grant on a website so that everybody knows that director review has been granted. The director can issue the decisions as precedential or routine. It is her choice. I won't go into the timing requirements, but just know that we do have timing requirements. And here's a quick overview of the statistics. 210 requests total, and of those, 15 total have been granted. 5 are from requests of the party, and 10 are the sua sponte, or on the director's own initiative review. Next, we could talk all afternoon about this topic, so I'm going to go super quick. We, at least in the United States, spend a lot of time talking about the director's discretion to institute a post-grant trial. But all I really wanted to go over here is that the director has put out some interim guidance and is requesting, or is about to request, more input from the party. There are several different ways that the director can exercise her discretion, but a lot of these have to do with in the post-grant proceedings where there are multiple petitions, and they can come either one after another, what we call serial petitions, or they can come at nearly the same time, what we call parallel petitions. And then the last category in blue is a favorite topic for legal discussion in the PTAB right now. It's when there is a trial in the district court and in the PTAB at about the same time, and there's a doctrine that we call fintive for shorthand, that tries to eliminate duplication of effort. And what I want to say about this is that right now the director has issued some interim guidance to try to clarify when the board will use the discretion to deny a trial at PTAB when there's an ongoing district court trial. And there are a few touch points, one of which is that right now we're not going to apply this doctrine to proceedings in the International Trade Commission. We will allow parties to stipulate that they will not raise duplicative matters in the district court and the U.S. Patent and Trademark Office. And if they say there will not duplicate the same challenges that they raised or could have raised at PTAB in the district court, then that will be a reason why we'll allow the PTAB trial to proceed. Another factor has to do with whether there are compelling merits, so that despite maybe some other factors that might weigh in favor of denying the trial, if the merits are compelling, that's a reason to continue. And the director put out some clarifications over the trial date because especially during COVID a lot, and we heard some about this yesterday, but the trial dates sometimes are very difficult because it's hard to conduct jury trials, at least during the lockdowns and COVID. So the directors put out some guidance on how the board should evaluate trial dates. I'm going to skip through a number of these just because they go over some of the same things that I've already talked about, the ITC, the compelling merits, the trial date. You can read about all of these, and quite literally we could spend the rest of the afternoon talking about these. Just know that the director intends to continue issuing more guidance on this, so this is not the last word by any means, and she does intend to get public comment and do some rulemaking. Now, there are some requests for comments. I want to briefly address one that just wrapped up. I mentioned before director review, the precedential opinion process, and internal circulation of decisions at the Patent Trial and Appeal Board. The director had put out a formal request for comment on these three topics. That comment period has just closed. Unfortunately, my slides were prepared before the comment period closed, but what I can tell you is that the director intends to look at all the comments. We got over 4,000 of them, so there are a lot of comments, but many are duplicative comments. So if you boil it down to the total number, it is maybe about 20 or so total comments when all is said and done. But we're going to look through those carefully. We're going to try to conduct some rulemaking. I have two quick topics. One, just to announce, we have a pro bono program that we are starting to help under-resourced inventors in starting out with appeals. And then we have what we call our LEAP program. This is a program that really is meant to benefit young attorneys and will give extra time to less experienced attorneys if they have 3 or fewer arguments. The idea here is really that this will help the next generation of patent practitioners hone their skills before the board. You can see that we've had, since we opened the program, 189 requests, and almost all of those have been granted. 89 law firms and companies have been represented, split about 2/3 in trials, 1/3 in appeals. And that's what I had for you today as the light turns red. So anyway, thank you all for your attention.
Thank you very much. And next is Dr. Ingo Beckdorf, Chairman of Technical Board of Appeal, European Patent Office.
Thank you very much, Konnichiwa, and thank you very much for inviting me to this symposium. I'm very glad to be back here after 4 years of a time when it was not possible. But let's not lose too much time on this. I will cover 3 main aspects. That's what we achieved so far in reducing the number of pending appeals. When I talk about appeals, this means what we call ex parte appeals, that appeals after refusing a patent application filed by the patent applicant, or inter partes appeals that follow the opposition proceedings. Second point is the use of video conferencing technology in conducting oral proceedings, and the last point will be the efforts that we undergo in the field of digitalization. First of all, on what we achieved so far, I go through the slides rather quickly. First of all, we had some objectives that were set to almost 5 years ago to address the issues of the high number of pending cases, and the first objective was to reduce the overall number of pending appeal cases below 7,000 and to deal and to settle appeal cases within 30 months. This does not sound too ambitious, but I can tell you this is only a first step to achieve, and we already start to look beyond that figure. So what we achieved in the first 6 months of this year is that we received some more cases than in the past. That was due to the pandemic, where obviously, I think not only in Europe, but in all places in the world, that there was a decrease in the incoming numbers of cases. However, we took this opportunity to reduce and to invest more time in dealing and settling the pending appeal cases, and we were lucky enough to reduce or to achieve the first objective of going below 7,000 pending appeal cases already now. The production has increased what we achieved before the pandemic, so this contributed to the overall achievement of the objective. Secondly, when we consider the settlement of cases, we distinguish between settlement of cases with action and without action. The important number is with action, because this means the case is settled either by a final decision of a board or in other way after the board already invested some time and, for example, issued a communication with some opinions already expressed to the parties on how the board considers and evaluates the case before it. And if you look at the graphs, I'm not going too much into detail, but at least there was an increase in the numbers, in our productivity numbers in the first year 2021, and we have a small reduction of the productivity, but I can tell you that we are back on track to increase this. I skipped this case because I already mentioned it, and now we come to the currently crucial point, that's the reduction of dependency time. This is considered by the boards of appeal to be far too long, and we invest some time and efforts to get this right in the future. If you see at least the dotted line in the middle, that is where we need to go, what we need to achieve by the end of next year, and then you see the columns, the blue columns, unfortunately be above the dotted line, and that's where we are. But at least there's a hopeful tendency that we reduce our pendency time, and if I understand the figures correctly, the current figures correctly, it seems to be that by the end of next year we will achieve the objective to have settled, to have no more than 10% of the pending cases older than 30 months in our stock. But again, this is only for the time being. We are currently discussing a new, what we call timeliness in objective that is far below that 30-month aim. Now, to address briefly some additional topics, that's the quality. Quality is very important. It's not just about numbers, i.e. quantity of decisions settled before the boards of appeal, but the decisions need to be of high quality as well. Numbers are not a value of its own. And for quality, we have established a very profound training program, internal training program for the members of the boards of appeal. Internally, that we have trainers, internal trainers among the members of the boards of appeal, and secondly, that we invite judges from the national jurisdiction to give lectures to us and to enable, to enhance an exchange of different approaches to always review whether we could improve in one way or the other. Apart from that, we have other quality issues. We have a regular exchange on our case law. We have our case law book that was the 10th edition of which was published only this summer. But this is a volume handbook, if I may say so, for all users, and users in this case also include the members, to have an overview of what is decided and what has been decided by other other boards. The rather modern issue is diversity and inclusion. This is an overall policy project of the European Patent Office, and we at the Boards of Appeal, we take this project up. In a first level, on first stage of this project, we try to enhance the awareness of what is covered by diversity and inclusion, which then forms the basis for the implementation of new measures to really come to some improvement in this area as well. When it comes, for example, of the number of female colleagues in the Boards of Appeal, this has always been one of the important factors when it came to recruitment. We would like to see more, but this is not just depending on the selection procedure, but it's also a matter of how many applicants you receive. And the last point on this slide is the Code of Conduct. This Code of Conduct came into force in July this year. It has been adopted by the Presidium of the Boards of Appeal. Presidium is a group of elected members and chairpersons of the Boards of Appeal, together with the President of the Board of Appeal. And this gremium, this Presidium, adopted a Code of Conduct with some key elements for the procedural behavior, for what is meant by the independence of the members of the Boards of Appeal. The subjects that are mentioned on this slide will be covered on the next slides, and I start with teleworking. With the pandemic, as all offices around the world, all courts around the world, we were faced with the situation that for quite some time we had a lockdown. Nobody was allowed to enter the building, and we had to invent some new, not to invent, no, it's too much, but we had to adopt some new measures how we could continue with the administration of justice, because it was clear that we could not just stop forever with oral proceedings, for example, in order not to build up even more on pending cases. And what was adopted here is that we, as of March 2022, in the first rollout, all members were equipped with new technologies to allow them to work from their home, from their places of residence, what we call also teleworking. Nowadays, every member is equipped with an iPad to allow to work with an electronic file. This is used in oral proceedings. We were all equipped with new devices, monitors and so on, in our home offices. And this was the basis for allowing us to continue our work. As of May 2020, we then started a bit later than PTAP. We started with oral proceedings by VICO. The first cases were conducted in oral proceedings by VICO in May, and then now we are in a different situation. I have a slide on this. What is ultimately linked or closely linked with the teleworking is the digitalization. We are more or less paperless these days. In my particular board, we became paperless 1 week before the first lockdown was introduced. First week in March, my entire board was equipped with iPads, and we destroyed more or less all paper files, and we went electronically from that day. That was actually 1 week before the first lockdown, and we could conduct the first oral proceedings already with these paperless means of working. We have a group of very experienced colleagues within the Boards of Appeal who did a tremendous job in internal training to allow everybody to switch over from paper to paperless. And for sure, we had also the support of the European Patent Office. Coming to more specifically to oral proceedings, here we have a new, or rather new, rule in our rules of procedure for the boards of appeal. That's the Article 15A of the Rules of Procedure 2020. It was adopted by our immediate supervisory body, that's the Board of Appeal Committee, and then approved by the Administrative Council, and it came into force more or less 1 year after the first lockdown. However, even in the meantime, we were able to conduct a fair number of oral proceedings by VICO. This was on a voluntary basis with the parties. And this came then also to before the enlarged Board of Appeal. The enlarged Board of Appeal, that's the highest judicial body within the framework set up by the European Patent Convention. And there was one case before the enlarged Board of Appeal, and that's the case G1 of 21, where the enlarged board held, this was related to pandemic situation, I read it out, during a general emergency impairing the parties' possibilities to attend in-person oral proceedings at the JPO premises. The conduct of oral proceedings before boards of appeal in the form of a video conference is compatible with the EPC, even if not all the parties to the proceedings have given their consent to the conduct of oral proceedings in the form of video conference. That's the end of the quotation. What does it mean? It means, first of all, that there was a legal question behind whether oral proceedings by video conference are oral proceedings in the meaning, in the terms of the EPC. Naturally, when the EPC was drafted in the 70s, nobody had any video conferencing system in mind or could even imagine that this become reality sometime in the future. But we were, on the other hand, we were forced to take decisions and not to stop working. And therefore, the first approach and the first row, we had these oral proceedings with the parties' consent, all parties' consent. It worked quite well because we could, even in the first year, I have a slide on this, could settle a number of cases already by video conference or after having conducted oral proceedings by video conference. But then towards the end of the year 2020, when the new rule in the Rules of Procedure, new article in the Rules of Procedure was conducted, a discussion was started. What should be the future? At that point in time, I already thought that we would come post-pandemic already in spring 2021. Okay, predictions are always difficult to make, in particular if they concern the future, but at least that was the situation, and therefore it was brought to the attention of the enlarged board. And what the enlarged board here did, first of all, it affirmed that oral proceedings by video conference are oral proceedings within the meaning of the European Patent Convention, and secondly, there might be circumstances where parties could be, if I may say so, forced to attend oral proceedings by video conference, or on the other hand also to allow the parties to request and to request a board to do the oral proceedings by video conferencing. However, in the end, and this has been laid down in this Article 15A of the Rules of Procedure, everything is at the discretion of the board. Coming to the next one, we have now a variety of options how to conduct oral proceedings. We have what we consider fully distributed oral proceedings. That means everybody is connected remotely. Even the members of the board, they can sit either in their offices on the premises of the boards of appeal, or they could sit at home in their home offices, the place of residence. And this is also true for all the attorneys. This is true for all accompanying persons. This is true for the public. This is fully distributed. And then we have some some other potential options, like what we call, for example, hybrid. This was discussed yesterday. There's no need for me to discuss this as well, but we have exactly the same system. It would even be possible, like Lord Justice Colin Burst said yesterday, that the members of the board could be remotely connected and the parties being in the room. At least this would be legally would be possible. It has not happened yet, but this would be one way to conduct oral proceedings in the future as well. The means that we use is Zoom. We started with Skype for Business, but then we switched over for Zoom, and this appears to be a very reliable platform for oral proceedings. What we still have is a continuous training for all members, for all chairpersons, to allow making the best of the oral proceedings by VICO. If you look at these this graphs, you see it ends in June 2022, but this is a continuous development that is true also this month in October. You see that in the past, in January 2022, and then throughout the year, the number of oral proceedings by VICO were the vast majority, how we conducted oral proceedings. There were always a number of in-person, in particular those who were located in Germany or closer to Munich, where the parties, where the attorneys could travel, could appear before the boards in person. Nowadays, we have more or less half and half situation, and in the future, I think it has become common in the boards of appeal, in my board in particular, that we summon all oral proceedings in person, and then it is decided at a later point in time whether the format is switched to VICO, depending upon the overall circumstances. So if I come now to the end, and this goes back to my first slides, overall, I think it could be a bit proud that we are on track to achieve our objectives, but these are only interim objectives, and we are already discussing future objectives to further reduce, in particular, the pendency time. We were successful in dealing with the restrictions during the pandemic, in particular by using video conference as the means, as the way of conducting oral proceedings, and the pandemic was a kind of trigger or motor to improve, to enhance digitalization at the boards of appeal. All in all, and regardless of any figures that I showed to you, quality has always been, is, and will be the key factor when it comes to evaluating our work. Thank you so much.
Thank you very much for your presentation. This is the end of our presentations about the latest trends for trials.